You must understand these fundamental principles of truth. A license is a permission given by a sovereign or a ruler to do something that is essentially, in its nature, unlawful or illegal. Are you clear? Does everybody understand what I just said? All right, you got that? Now, these are from my notes from a class of 1987 that I gave at my house for students of the round table. How many of you familiar with the divine warning for the nations by the prophet Noble Drawley? You are? All right. Are you familiar with the section where he says that the 14th and 15th Amendment is not necessary for the salvation of my people and the citizens? Is anybody familiar with that coming from Drawley in the 20s? You're not? That's why I want you to pay attention, because I got to make sure that I build a foundation for you so you understand how to approach this. Because this is being enforced right now while I speak, though it's not being said to you. You understand? Even with the immigration problem they have, this is what's being enforced. But it's also causing them problems now. Do you understand? It's sort of like a Pandora's box thing. All right? I can't find it at the moment, so I don't want a lot of dead time. But I'm going to refer to you. In the divine warning to the nation is one of three major dissertations in written and oral form given by Noble Drawley since 1913, just before Woodrow Wilson was elected to the presidency, to the Moors of North America, in propria persona, in his proper person, to speak for these people who have been disinherited from their birthright, who think they're Negroes, West Indians, Latinos, and all these things, all of which they're not, that come under the 14th Amendment construct of artificial persons in order for Europeans to hold bureaucratized servitude here in North America. It's a political tool, but unknown to the people who are subjected to it. Do you understand what I'm saying to you? Now, then I'm going to read this now so to put this in context. You got to make notes of the paragraph wherein the 14th Amendment is dismissed. That's in the divine warning by the prophet to the nations, which I don't have right now, but make sure y'all have that literature in the future so you can study, because it has everything to do with right now. Do you understand? That's why it was given to you earlier in the century, so that the generations could be prepared for what was to come. You understand? Don't take my word for it, do the research. But I'm giving you keys so that you can see it for yourself. Because you're going to need it. You needed it, but you're going to need it even more so as this thing moves along within this year and the coming year, when this stuff hits bottom, which it's going to do. It's not maybe, it's going to do. Now the alleged, write that down, emphasize that, alleged, put lines under it so you can go understand what that word means. The alleged ratification of the 14th Amendment to the United States Constitution is rightfully declared by the erudite of law to be void of law and not a part of the Republic's Constitution. Are we clear? Just put it in your own words. It's not constitutional. And I'm going to show you why in law. Now, we will address some of those facts surrounding these affirmations of law and history, which we're doing. And this is vital inasmuch as the controversial 14th Amendment proposal remained in law just that, a proposal, which was never lawfully ratified. Now, in your spare time, go read the 14th Amendment and see what it implies. Then you analyze it, which is an implied political relationship to people held artificially to peonage, which has the tradition and has been traditionally by connotative language referred to as slavery. Now, Andrew Johnson, European, was elected to the seat of the presidency 1808, and of course he lived to, no, he was born 1808, I apologize, and he lived to 1875. Now, 1865, he ascended to the office of the presidency due to the assassination of Abraham Lincoln. Are we clear? Now, we won't go into the Emancipation Proclamation of 62 and 63 because it'll take up too much time and I want to keep you focused. All right? But understand, that's another legal issue. Manumission does not mean free. It just means you're transferred to another hands of responsibility. Of course, people who don't read and who's preoccupied by overseers who were given the title of preachers think that they were saved. They were not. The European families transferred their estates to the Congress. And the people under the 14th Amendment are transferred just like real estate. So when you look at the rules that govern real estate, just like this building, people called Negro, Black, and Colored are transferred exactly under the same laws, under the 14th Amendment, which is why it's necessary to know this. And why all corporations register in the state of Delaware under the 14th Amendment. Artificial persons. Get the point? This is very important. I want you to make sure you have these concepts right, have them down. Now I'm going to give you some historical, congressional record facts so that you can understand the point that I'm telling you this and what you need to know and why you need to get deeper into this and get yourself in order. Now these are facts. First, Andrew Johnson was president, presiding at that time. Of course, that's after Civil War, which commenced in April 65. Since the assassination of Abraham Lincoln, April 65. Now, Thaddeus Stevens, he was a European holding a seat in the Congress of the United States Republic, was one of the primal advocates among an agreeing body of Republicans who were at that time referred to as radical Republicans, who were proposing this bill to free these people. And it must be kept in context that the Ku Klux Klan was working, doing the dirty work for the Democratic Party to maintain this servitude. So this was a political split amongst them. Everyone that stood for freeing these people or giving them some kind of rights were Republicans. Everybody who was maneuvering to enslave them were Democrats. And the Ku Klux Klan was working for the Democratic Party to be lynching and burning our people. It's very important. Save your questions because I want to get these points out. But don't write your questions down. Don't lose your train of thought. Now, the advocating Republican congressman promoted the proposition that the use of federal power was needed and necessary to construct and initiate a new order. And that new order was to be implemented in the southern states, wherein the south districts of the republic would be made whole and safe by promoting full citizenship for the quote-unquote alleged to be freed descendants of Africans designated as slaves, etc. When you understand this, you understand when Noble Raleigh said this was used, the 14th Amendment was used to bring the South back into the body of power. So you can understand, so you must put Noble Raleigh's statements in context with these historical facts of the congressional records. Do you understand what I'm saying to you? Now, This political initiation of events and intersocial affairs constitutes an important part of the period known as the Reconstruction period, which you already know. This is the period of Reconstruction. I'm trying to skip through some of this because I don't want to be too worried. I want you to get the concept. The Reconstruction activities began in 1865 and continued into its most active forms until 1877. Now, the facts of law supreme must be taken into cognizance when any proposal for amending, which is really emanding, the Constitution is taken into consideration. So we're setting the groundworks in law or how the Constitution is amended. So you must understand this so you can understand your arguments. Say if the IRS come at you, tell you what you owe, and then you're trying to take a stand, you know what I'm saying, of a true status of right versus being a protester, which they will classify you as under the subjection of the 14th Amendment as a Negro, which makes you subject. Get the point? All right, now, A, in order for an amendment to be considered, even considered for ratification, it must first be proposed. Are we clear? It can't even be considered unless it's first proposed. Are we clear? B, the Constitution for the United States Republic of North America provides only two lawful methods for such a proposal of an amendment, etc., to be even presented. Are we clear? Only two forms, two methods. C, a proposal for amending the Republic's Constitution requires by convention, which means there must be a constitutional convention. Without a convention, there can't be a proposal. And without the proposal, there can't be ratification. Are we clear? All right. And so it requires by convention the agreement of 2/3 of the state republics. Are we clear? So 2/3 of the state's republics must be in agreement for the proposal to even be presented for ratification. So we ain't talking ratification yet. We're talking about even for it to be proposed. Are we clear? All right. And so that's 2/3 of the membership of both houses, the Senate and the House of Representatives. Are we clear? Now note, as in the political controversies involving the proposal of the 14th Amendment, the congressional accommodation of the law was initiated. So it was initiated, and the historical political facts must be taken into consideration when the 14th Amendment analyzed for validity and non-validity versus non-validity, etc. Now, the conditions that are set forth by the supreme law of the land Constitution requires by law that no state without its consent shall be deprived of its equal suffrage, which means vote, etc., in the Senate. Are you clear? Now, this is a conditional fact. When the 14th Amendment was proposed by the Republicans, referred to as the Radical Republicans, exactly 23 senators were unlawfully excluded from the United States Senate. And this was done for political expediency in order for the proponents to achieve the legalized appearance of a valid adoption of the proposal for the 14th Amendment. Now, among the senators excluded for political purposes of color, that's not complexion, color law,